This lecture is about legislation and parliamentary sovereignty. I want to deal with a couple of themes in outline before I go on to talk about them in detail. If we are turning our attention to legislation, we're turning our attention to one of the main sources of English law. Let me just outline the other sources of English law so we can understand what statute or Acts of Parliament or legislation is all about. We could start with something we've been thinking a lot about, which is common law. Now let's say, again, this might sound rather basic, but it's a good working definition. Common law is judge-made law. It's the law made by judges in cases on an ad hoc or case-by-case basis. We could also say that a source of English law, is the law of the European Union, and another source is the law of human rights, which derives from the European Convention on Human Rights. This leaves us with statute. Let me say a little bit more about statute. Statutes are made by Parliament. They are acts of Parliament. There is a process by which statutes are made, which I'm not going to say a lot about in this lecture. I'll show you a link where you can look at the process by which an act of Parliament is made. But the point that I really want to stress is that our concern here is with the lawmaking function of Parliament. And when we turn our attention to legislation, to acts of Parliament, to statute, we're looking at the general law that Parliament is making. Just by means of definition and clarification, I want to say a little bit about delegated legislation. Now, delegated legislation is, as the title might suggest, legislation which has been delegated by Parliament to some body to make. So, when the British Railways Board existed, for instance, Parliament delegated certain lawmaking powers to that board in order to make rules and laws that related to railway lines, such as the provisions relating to trespass on railway lines. So that would be an example of delegated legislation, because a particular body would have powers given to it by Parliament to make certain forms of limited law in relation to a particular specific area of activity. I want to say much more, though, about parliamentary sovereignty, because to talk about the lawmaking power of Parliament really takes us to the heart of the British Constitution. And at the heart of the British Constitution lies the doctrine of parliamentary sovereignty. So what is parliamentary sovereignty? Well, I used the word a moment ago, which was the idea of lawmaking power, the power to enact legislation, the power to make acts of Parliament. This relates to the concept of sovereignty. We could say that the concept of sovereignty explains lawmaking power. Let me say something more about the British Constitution or the English Constitution in order to build that point. What we are thinking about when we're thinking about a constitution is the way in which the power of the state is codified and organised. As you may know, there is no fundamental single document of the British Constitution. There is no fundamental constitution like there is in most places. The Constitution of the United States would be a good example. There's no single written source for the British Constitution, but we could say that, in fact, one scholar has, I think, interestingly said that instead of a constitution, the British have history. In other words, we have historical sources of law which provide rules, principles of constitutional importance to the extent that they relate to the powers of the state and the powers of the individual vis-à-vis the state. So parliamentary sovereignty is a doctrine, a way of thinking, a set of rules, a set of principles that take us to the core of the idea of the British Constitution. And the idea of parliamentary sovereignty, or the lawmaking power of Parliament, is fundamentally a democratic idea. It may not appear to be so as this lecture continues, but this is the fundamental idea. It explains the following point. Any constitution must have a supreme source of lawmaking. We have to be able to point to a body in any given constitution and say this body makes supreme law. In other words, the buck stops with whatever that body is. If there is inconsistent law, the law made by this body will override that inconsistent law. How does this relate to the point about democracy I was making a moment ago? Let's go back to the idea of Parliament. Parliament, as you know, is elected on a democratic franchise. The people of the United Kingdom vote for the government that will rule from Parliament, that will have power in Parliament. The power ultimately, in this sense, the power to make law. In other words, that power to make law reflects the will of the people expressing itself democratically in a general election. Now, we could say that provides the theory that underlies parliamentary sovereignty. If we're saying that Parliament is the sovereign body, that Parliament has supreme lawmaking power, then that, in a democracy, should ultimately be justified and defended by the idea that the lawmaking power of Parliament reflects the will of the people. Now, that would all seem to add up, wouldn't it? But if you remember at the beginning of this lecture, we were talking about the lawmaking power of judges. So this begs the question, what is the relationship between the lawmaking power of judges and the lawmaking power of Parliament? Well, I suppose I've used a word that already goes a long way to explaining this relationship. And that is the idea that the lawmaking power of Parliament is supreme or sovereign. In other words, if Parliament makes a law and a judge has ruled and made a law in a case, and that rule or law made by the judge is inconsistent with the rule or law made by Parliament, the Parliamentary Act, the statute, the piece of legislation, will state the correct rule. It will override any inconsistent rule of common law. This raises some very important questions about the relationship between the common law judges and Parliament. Now, we know, and it's a fact of the British Constitution, that Parliament is sovereign. Parliament has ultimate, supreme lawmaking powers. Judges have subordinate lawmaking powers. Now, at the beginning of this lecture, I mentioned the law of human rights. What we have to do, I think, to understand the contemporary reality of the lawmaking power of Parliament is see it as operating within the context of human rights, where judges also make rulings on human rights. It would follow, wouldn't it, from our argument so far, that given that Parliament has supreme power, Parliament can overrule any laws made by judges, and that would mean that they could also overrule laws or principles articulated by judges that relate to human rights. This remains true, but there's clearly a problem, because it would be damaging, let's say, for the legitimacy, for the extent to which people agreed with the power of Parliament, that it should be seen to be operating in such a way. I want to come back to these points because I think it takes us to a lot of difficult contemporary problems that relate to issues of human rights and supreme power within the British Constitution, and also, as I've mentioned, to the power of the judges. There's another source of law I mentioned at the beginning of this lecture, and that is the law of the European Union. And the law of the European Union also impacts on the sovereignty of Parliament. Now, I said in an earlier lecture that the law of the European Union, or the law articulated in part by the European Court of Justice in Luxembourg, is supreme in a nation state, so in the United Kingdom. So this would suggest, wouldn't it, that the law of the European Union limits the sovereignty of Parliament to the extent that European Union law is supreme. It would override inconsistent provisions of acts of Parliament. Now, this is a theme I want to pick up later on, but it does suggest that this doctrine of the sovereignty of Parliament has to be thought about within the context of that contemporary reality, where the law of the EU and the law of human rights forces us to ask certain critical questions about the parameters of parliamentary sovereignty. Let me just return to my main points by means of summary and clarification. We're concerned with legislation, we're concerned with Parliament, and we're concerned with parliamentary sovereignty. Now, acts of Parliament, we could also say statutes or indeed legislation, are forms of law produced by Parliament. They are the supreme source of law in the British Constitution, and that, as I mentioned, is ultimately justified on democratic principles. My second, I suppose, line of argument was that this fundamental doctrine, the doctrine of the sovereignty of Parliament, needs to be thought about critically in the light of recent legal changes and developments, such as the impact of the law of the European Union on the United Kingdom and the impact of the law of human rights on the United Kingdom.